Start record. All right, good morning, everyone. I am Hillary Haynes with the Greater Bakersfield Chamber, and I'm your host for this morning's labor law and HR webinar that is sponsored by LeBeau-Thelen. Oh, I just saw, no, we can't hear your mic. No, everyone is muted. Sorry, I just saw a message come up. We appreciate their support because it allows us to provide these important labor law forums as a service to our members. So today we will hear from Daniel Klingenberger, who will be providing updates about the most important policies California employers should have in place in today's business environment and explain why the policies are central to protecting businesses. So Dan will cover other topics such as sick leave, leave of absence, meal and rest periods, pregnancy disability leave, and unlawful harassment. He will also, at the end of the session, cover any COVID-related updates. So if you guys have questions regarding that, feel free to ask them. I emailed everyone the PowerPoint presentation yesterday afternoon, so feel free to follow along and take notes. As noted in the email, the Chamber also has 2021 labor law posters for sale. So if you still need one of those, we have had people, now the offices are back open, stopping by frequently. Before we get started, I just want to encourage everyone to use the Q&A or the chat box to ask your questions or make comments. You can also use the hand emoji, so I can unmute you and you can ask your question live. So the little hand emoji will notify Dan and I that someone has a question to ask. So with that, I'd like to turn it over to Mr. Klingenberger.
Great. Thank you very much, Hillary. I appreciate
You're welcome.
the opportunity, and always fun to have the chance to talk about an important topic like employee handbooks. It's a topic that sometimes gets overlooked, I think, by businesses because it may seem rather mundane, and companies struggle with, should I have an employee handbook? Should I not have one? And then a lot of companies struggle with, how do I go about getting the handbook in place and dealing with the issue? I know it's a project that can sit on the HR person or the owner's desk for many months because it can be rather tedious to put it together. But what we're going to do today, I think, is hopefully unravel some of that and talk to you about some of the key provisions that I think should be in an employee handbook, and also talk about why handbooks are important for an employer, for any business to have. So we're going to work through this here with your program overview there. We're going to talk about the purpose of employee handbooks, some of the myths that are associated with having or not having employee handbooks. We'll talk about language to avoid as you're reviewing your own employee handbook or beginning to draft an employee handbook. And then we're going to talk about what I consider to be the key policies that employers should have, as well as other common policies. And then lastly, we'll talk about the implementation and the actual distribution of the handbooks themselves. And handbooks, mean different things to different people. I've seen handbooks that, are as few as 10 pages and handbooks that are 80 pages. And, different companies have different philosophies about what should be included in an employee handbook. I want to start out by saying, first of all, that there really isn't any legal standard that says exactly what is supposed to be in an employee handbook. As you'll hear, as I'm working through the different policies, there are policies that employers are required to communicate to their employees. For example, an unlawful harassment policy. Every company is obligated to have such a policy and communicate it to its employees. Whether that's done through an employee handbook or some other vehicle can be up to the employer to choose. But since there are many things that employers do need to communicate to their employees, the handbook ends up being probably the most simple and useful tool to make that happen. So we'll talk about those things as we move through. So initially then talking about the purpose of the employee handbook, it is to meet legal compliance because there are certain policies that are required by law. As well, policies can create important defenses for employers. We unfortunately live in a very litigious state, and we see a lot of cases filed against employers, whether it's in Superior Court or with the Labor Commissioner or different agencies. And inevitably, when those type of cases are filed, at some point, you're going to get a request from who's ever bringing the claim, or from whichever agency is addressing the particular claim that's been filed. You're going to get a request for a copy of your employee handbook. And even though technically, legally, you don't have to have an employee handbook, because there are certain policies that you are expected to have, the agencies are going to be looking for you to provide those policies to them to demonstrate that you're taking that particular topic seriously, that you've communicated to employees important information related to that particular area of the law. As an example, and we'll talk about this more as we go through, if you have a claim filed with the Department of Fair Employment and Housing, let's say the claim is for sexual harassment or some other form of unlawful harassment, the DFEH will be asking you to provide your copy of your policy against unlawful harassment so that you can demonstrate that you know what the topic is. You've communicated to your employees how to address complaints if they feel they've been the victim of unlawful harassment, and that you know that if you get a complaint, you're supposed to do an investigation and things like that. So that is one of the first things that these agencies and plaintiffs' lawyers are going to be asking for, and the content of your employee handbook can often serve as an important starting point for your defense of those claims. Handbooks can also be used to communicate company history and culture. You can tailor the handbooks to your particular company and explain to especially incoming new employees a little bit about your company and how you operate and the culture you're trying to create. You can set company expectations. The handbooks typically include policies that tell employees, for example, that you don't tolerate, workplace violence, that you have a set of standards of conduct that the employees are expected to follow, that you expect them to follow attendance and punctuality rules, and that you're going to hold them to that standard and potentially discipline them if they don't meet those standards. So the handbook, again, is the most simple vehicle to make sure you're communicating those expectations to employees. It also serves as a resource for management and staff. So when employees have questions, whether it's management team or a staff employee, they can go to the employee handbook as a resource to see, well, what is our policy on pregnancy disability leave? What is our policy on meal periods and rest periods and things like that, so that you've already established those things and communicated them to your employees, and it then becomes a resource for everyone involved to understand what the company's expectations are. And then lastly, it can be used to establish operational policies. So if you have, for example, a safety policy within your handbook, or you have some specific guidelines about how your particular company operates. Let's say, for example, you're in food service and you want to include in your employee handbook some specific expectations of food handling procedures and things like that. The employee handbook can be used as a document that can communicate those things to your workers as well. So there's a lot of potential benefits that come from employee handbooks, and I think the employers stand to gain a lot by using that handbook as that method of communicating those things. So some myths associated with employee handbooks that I've dealt with over time. Did you have a question, Hillary? Sorry.
Yeah, it looks like someone does have a question.
Great.
So Tanya, you want to go ahead and ask your question?
Sir, I didn't mean to hit the hands up button. I don't have a question yet.
Okay.
So sorry.
Okay.
All right. Thanks, Tanya. Tanya is herself probably an expert on employee handbooks anyway, so so appreciate that. But if you do have a question, anybody does, feel free to jump in or type it in as well, and we'll try and field those as we notice them as we go along. So again, myths that are associated with employee handbooks. The first one I have there is that If I establish policies, I tie myself down and lose flexibility to operate my company. And I've heard that comment made over the years from time to time, because some owners say, I don't really want to, really establish policies that then I will be bound to and won't be able to make decisions to operate my company the way I want to. And I understand that philosophy, I understand the concern, but I think in reality, the handbook actually helps you operate your company better, because by creating the employee handbook, it forces an employer to think through so many issues related to their company. The process becomes something of an audit, almost a self-audit of many legal obligations that companies have. And so, for example, if you're thinking through your employee handbook and, well, what is going to be my meal and rest period policy? What is going to be my expectation as to attendance and punctuality? What do I want to establish as standards of conduct that I'm going to hold my employees to, and let them know that they're going to be disciplined if they don't adhere to those expectations? So I think the process and the handbook itself ultimately gives you more flexibility as a company, because the handbook is going to be written in a way that allows you to modify it going forward. It allows you flexibility, allows you to apply your own reason and judgment in terms of how you address issues in the workplace. And because it does also provide you with the opportunity to comply with certain legal obligations, I think that that general myth of that philosophy really ends up in a place where employers are really best off if they pursue an employee handbook. The other myth is similar. It says, I don't want to be bound to a contract. The concern is that, again, I'm going to be so specific in my employee handbook that now I won't be able to run my company the way I want. And for the same reasons, I think the employee handbook, if well drafted, actually gives you a lot of opportunity and flexibility to run your company as you like. All right, so let's talk about some language to avoid in employee handbook. So I suppose I'm kind of starting with the negative here, but as you're thinking about your employee handbook or reviewing the one you have in place, or you're looking at resources out in the marketplace that might have an employee handbook, I think it is important to make sure you're careful about what handbook you end up with, because there are resources out there that provide draft language for handbooks that were not created for a California employer and don't include language, or maybe do include language that a California employer does not want to have in their employee handbook. Or you're internally you're creating or drafting some language, for example, communicating the company history and the culture, and you're drafting that yourself because you don't have any resource to create that for you. There is language you want to make sure you're careful about including or not including in the employee handbook. So, and this first point in terms of not using terms which allow second guessing, this kind of goes to my point earlier that with respect to the myth about employee handbooks, that you do actually want to create a handbook that does give you flexibility in how you run your company. So the tendency can be sometimes when you draft an employee handbook is that I want to communicate to my employees that I'm the most honest, fair, and well-intentioned employer in the country. And so I want to communicate to them that I'm going to treat all my employees in a fair and consistent manner. That sounds very nice, and it's a wonderful thing to say and a wonderful thing to believe, but it's not a good thing to include in your employee handbook, because if you're at a point down the road where you are involved in litigation, and let's say you have an employee who is challenging how they were treated and questioning whether, for example, they should have been terminated, or whether they should have been demoted or not transferred, or whatever their complaint is, if that decision that you made is being challenged, then you don't want the employee handbook language to be the source of an argument by plaintiff's counsel that, well, we don't think you treated your employees in a fair and consistent manner. So of course, do you want to treat your employees fairly? Yes. Do you want to be consistent? Yes. But the point is that be careful about including language like that, in your employee handbook. Similarly, the second point there, we will be reasonable in all our dealings with employees. So what does reasonable mean? Who gets to define that? Do we even know what that is as an employer? That type of language, again, although sounding good, can ultimately hurt you if you're ending up in litigation and having the words of your handbook challenged through a plaintiff's counsel scrutiny of your employee handbook. And the same idea with the last point there about, we'll evaluate and reach an equitable decision. Of course, that's what you want to try and do. You want to be fair to your employees. You want it to be equitable. You want to be consistent. But again, be careful about using that type of language in your employee handbook itself. Other things to avoid, language that says this is not a contract. That is not language you want to have in a California employee handbook. In other states across the country, you do want to have that language in your employee handbook. This is a variant that depends on basically different state law. In California, the courts have said that although the employee handbook is not a contract, it kind of looks and smells a little bit like a contract. It's a quasi-contract type document. And the things that you put in your employee handbook are creating something of an implied contract as to the terms in the document. Now you might say, well, gosh, I don't want that. I don't want anyone to be interpreting my employee handbook as a contract-like document. Again, I want the flexibility. I don't want to be bound to all these things. So it gets back to how you draft your handbook and making sure that you're careful about the words you use. But since the courts are basically going to be treating a lot of the things that are in your employee handbook as something that you've essentially communicated to your employees and communicated to them as something that you want to stand by as far as how you're running your company, then it's better to not say that this is not a contract since the courts are going to take a different view anyway. And one of the key areas that this becomes important is that every employee handbook, unless you're a union organized company, or perhaps a public sector employer. But for private sector employers, one of the standard policies that you're going to want to include is language that says that you are an at-will employer and establishing the at-will relationship between you and your employees. I'm going to talk more as we go through about what that means, what the at-will language is intended to cover, what its strengths and weaknesses are for you as a company. But just looking at it from this language to avoid perspective, first of all, if you include the at-will language in your handbook, as I would recommend that you do, then you don't want to establish that at-will relationship in your handbook, but then also include language that says this is not a contract, because those are mutually inconsistent. You want that at-will language to basically be enforced in court as something that you've legitimately established with your employees. So again, I'm not to hammer this too hard, but just be careful about including this is language to the effect that this is not a contract in your employee handbook, because many draft employee handbooks from outside of California do include that language because it's a matter of state law wherever it was drafted. Okay. For similar reasons, you don't want to say, this handbook is for your information only. It is for your information, and you can have language like that, but it's not just for your information only. And we don't want to say that we can change this contract or change this document without notifying the employees. In fact, we're going to say the opposite. We're going to let them know that if there are changes to the employee handbook, that we will let them know, and we'll communicate that through a modified handbook or a modified policy, and we'll let them know about those changes in writing. So that's also common language to include in the employee handbook. All right, so other language to avoid then, talking about at will, is language that is inconsistent with being an at will employer. And so before I talk about some specific types of language that would arguably be inconsistent with being at will, let's talk about what at-will employment is first. I'm going to digress a little bit to talk generally about this topic of what at-will employment is, and then we'll get back to the handbook language specifically and what we should be drafting an employee handbook. So let's talk about at-will relationship, because this is a topic that comes up a lot in a whole host of different ways from an HR perspective. It's a topic that I think is often misunderstood by employers and maybe overused in some respects. And I think it's also important for employers to understand that although being an at-will employer is important, and it's important to have it in your employee handbook, there are limitations as to what it does for you. And I'm going to talk about those limitations in just a minute. So starting with just some sample language, that you could include in an employee handbook is what you see here. The company's employment policy is at will. Under the at-will policy, neither you nor the company is committed to continuing the employment relationship for any specific term. Rather, the employment relationship will continue at will. Either side may terminate the relationship at any time, with or without cause and with or without notice. Also, the company retains the right to demote, transfer, change job duties, and change compensation at any time, with or without notice and with or without cause, in its sole discretion. In deciding to work for the company or continuing to work for the company, you must understand and accept these terms of employment. So that is one way of communicating an at-will policy. There are other ways. There's other language that would accomplish the same result, but this is the language that I would typically use. In addition to this language, I'll talk about in just a second, but I didn't put it on this slide specifically. Normally with an at-will policy, I would also make clear that this at-will relationship can only be changed in a writing signed by the CEO or the president of the company. And I'll address that in another slide in just a moment, but I would normally add that to this policy. So that's a general statement of at will. It basically says that you don't have to have good cause or just cause to terminate an employee, and that either side, the employee or the employer, can leave whenever they want, can discontinue the relationship whenever they want. So, we do want to include the merger and integration language that says that the document cannot be altered, amended, or modified except by a writing signed by the president CEO. And that's important language to include because of general, what we call contract law principles, that we want to make clear that we are establishing the at-will relationship, and we're establishing it in a manner that is a done deal, so to speak, unless we specifically tell you in writing something to the contrary. And so this is important because what plaintiffs' lawyers will often argue is that, well, yes, you established your at-will relationship, you had good at-will language, but then later on, one of your supervisors promised a former employee that, well, I know we're at will, but in reality, I think that you can expect to work here probably for the rest of your life. Really, we've never terminated anybody without, super great reasons. And so don't worry, about the at-will language. You can expect that you can retire here at some point in the future, or some other language that is promised to the employee verbally that unravels or undoes the at-will policy. And so to prevent an employee from arguing down the road that some supervisor, some random supervisor perhaps, made a comment like that to them during the course of their employment, this merger and integration language helps you demonstrate that, sorry, maybe some supervisor said something like that, but we've made clear in our employee handbook, in our at-will policy, that this at-will relationship can only be changed in a writing by the president or CEO. So it's important to have that language in there as well. So looking then at this at-will relationship, I think it's important to understand that although establishing yourself as an at-will employer is very important, there are some limitations. So First of all, you're going to have your at-will policy. You're going to have it in the body of the handbook. You're also going to have it as a separate sign-off sheet as part of the employee handbook to reaffirm that they are at-will employees. You have Labor Code Section 2922 in California that basically says that California is an at-will employer. But again, that Labor Code section can be undone by promises that are made to the employee by a supervisor, which gets you back then to having good language and having the integration language. And then it's important to understand, I think, what the at-will language really does for you as an employer. It is saying to the employees that essentially either one of us can discontinue this relationship whenever we want, but and also that we as the employer, we don't have to meet some standard of quote unquote good cause or quote unquote just cause to terminate you. We can terminate you with or without reason and with or without notice at any time. And so that's clearly communicated with your at-will language. And so that helps you because if an employee or former employee later brings a claim and argues that you terminated them for a reason that did not constitute good cause or just cause, then you would be able to defeat that claim in court by trotting out your at-will policy and saying, hey, we're an at-will employer. We don't have to have good cause or just cause to terminate an employee. And so the at-will language is primarily beneficial to employers to be able to defeat that type of what's called a breach of implied contract that just causes needed to terminate. So it has kind of a specific and in some ways limited benefit to employers. But even though I'm saying it's limited, I still think it's important to have it, but you just need to understand that it does have some limitations. And the biggest thing about the limitation of having the at-will language is to understand that even though you are an at-will employer and you clearly establish that through your policy, the at-will language does not protect an employer from a claim that someone believes they were terminated or discriminated against or harassed based on something that is protected by public policy. So an easy example would be if an employee claimed that you terminated me because of my national origin or because of my religion. And if they could prove that religion or national origin did play a role in the decision, say, to terminate that employee, then, and if they could prove discrimination, then we all know that the at-will language isn't going to really help you because we are not allowed as a matter of law to discriminate against people based on protected statuses. And there's a whole host of different public policies that an employee could claim are the basis for them being terminated. And so this gets us back to the point that from an HR perspective, it is still recommended that companies use good documentation, that they write down the issues they're having with employees, they give warnings, they give opportunities to improve, and keep a paper trail to demonstrate that they did those things. Even though you may be an at-will employer, you may need that documentation and that evidence down the road to defend a claim that the person was subjected to some type of adverse employment action because of them being in a protected status or because of a violation of public policy. So in terms of what these public policy claims might be, there's really too many to list. It goes on for pages in California as to the ways that employees could contend that a reason that they were terminated was protected by public policy. But it could include, the 17 protected statuses that are typically already included in your policies, race, religion, national origin, disability, all those kinds of things. Maybe a complaint about safety, a complaint about financial improprieties, a complaint about unlawful harassment. If the employee can demonstrate that the reason the adverse employment action was taken against them was because they were in one of those protected statuses or engaged in some type of protected conduct by reporting, say, a safety violation, then again, the fact that you're an at-will employer isn't going to help you to defeat that claim. So again, I just want to point out that although it's important to have at-will language, it does not mean that you can truly, terminate people for any reason. You cannot terminate them, obviously, for unlawful reasons. So some language then to make sure we do not include in your employee handbook, to make sure that you don't have language that's inconsistent with your at-will language, would be things that are promising the employee something that is different than being at will. This is a great company to build your career. Now, do you want to have employees build their careers? Do you want to communicate positivity about the company and things like that? You want employees to expect a long and successful career, to expect job security and stable employment. Sure, absolutely, you want those things, because that can be creating the kind of culture that makes employees happy and establish between you and them employees that are going to stick around a while. The point is, though, that you don't want to necessarily include that language in your employee handbook because that could be inconsistent with being at will. Similarly, the last point there, some reference to being a permanent employee. We don't see that language around so much anymore, but you want to be careful about use of words like permanent to describe the long-term relationship with the employee. Other language that could be inconsistent with at will is a language to progressive discipline. So, progressive discipline, as we know, is tools that employers use to give employees the notice of problems and the opportunity to improve on those problems. So it's giving them a verbal warning, perhaps a written warning, maybe a suspension, a demotion, taking steps short of termination to let the employees know that they're not performing up to the expectations of the company. Progressive discipline is a wonderful tool to use. It's an important tool to use to communicate to your employees that they, in fact, are not meeting the requirements that the manager wants. But that's different than creating in your employee handbook some set of rules or list of steps that you're going to follow before you terminate an employee, where you are committing yourself to following those steps before you let someone go. That type of progressive discipline, if documented in your employee handbook, would be inconsistent with the at-will language. And so you don't want both in your employee handbook. If you don't want to be an at-will employer and you want to commit to using progressive discipline, that would be your prerogative. But typically better to have the at-will language in your handbook and then use progressive discipline, but not documented in the employee handbook as a means of managing your workforce. Similarly, if you make reference to just cause or good cause to terminate an employee, again, that's inconsistent with being at will. Reference to a permanent employee, as I said before, a reference to a probationary period can also be viewed as inconsistent with at will. So that's terminology that is better to not include in your workforce, this idea of probationary period. The more common and modern way of referring to that type of period is perhaps an introductory period, which basically accomplishes the same idea, communicates the same concept, but a probationary period could otherwise sort of imply that once they've completed that probationary period, that they have some greater expectation of a long-term relationship with the company, and again, could be used to argue that it's inconsistent with being at will. Again, not a slam dunk argument necessarily by a former employee, but better to avoid that language in your employee handbook, just because it's really not necessary. All right, so with that said about employee handbooks, at will employment and language that's inconsistent with being at will, let's get back to some of the other concepts about employee handbooks. So let's talk about some of the key policies that I think should be included in an employee handbook. As I said earlier, there's a lot of different kinds of policies that employers can have in an employee handbook, and there really isn't any rule that says exactly how long a handbook should be or shouldn't be, or what should be included or should not be included. But there are certain policies that I think every employer should have, in some form of employee handbook to communicate to their employees. So First on that list is some policy regarding equal employment opportunity, an EEO type policy, a statement that you as a company are committed to equal employment opportunity at every stage of the employment relationship, at the application stage, the employment stage as well, when you're considering promotions or demotions or any other changes of employment, that you're committed to not making those decisions based on some type of protected category. And so we know that in California, between California and federal law, there's a long list. I think it's, as my slide earlier said, about 17 different protected statuses, at least, that exist in California. And so you want to include in your EEO policy a list of all of those protected categories. Now, typically an employee handbook will list all of those and then, add a caveat at the end along the lines of, in any other protected status under state or federal law. So in case you missed one, or in case one is added, you're still covered. But it's best, I think, to include as comprehensive a list as possible of the different protected statuses. And these do change over time. We've had in the past few years sexual orientation, gender expression, gender identity, just as some examples of newer protected categories that weren't there 20 years ago. So we want to make sure we have a comprehensive list of your protected statuses. It's a good idea to also include that people are protected not only based on being in a protected status, but the perception that they're in a protected status, or in some cases that they're associated with someone who's in a protected status. So those things can all be and should all be included in your EEO statement or your EEO policy. Include language that talks about reasonable accommodation for individuals with a disability and who they should ask for an accommodation from. Again, whether it's at the hiring stage or if it's a current employee, whether they've been there 1 year or 20 years, that the company will consider reasonable accommodations for individuals with disabilities. So include that language in your policy as well. Include a complaint procedure for applicants and employees if they feel they've been subjected to some type of discrimination that violates your policy, or they need some type of accommodation. In that procedure, list more than one person to inform of a complaint. So employees have more than one opportunity to tell someone that they feel they've been the victim of some type of discrimination or harassment. So maybe they go to the HR person, if you have one, or maybe the most senior manager, maybe also the president or the CEO, so that in case the first person the employee complains to doesn't take action or doesn't take appropriate action, that your policy is at least communicating to that worker that they have other opportunities to tell someone else and not just stop with the first person who they inform about their concerns. The policy should also include a statement of no retaliation against the individual if they do bring a complaint about some type of discrimination or harassment. Along with your EEO policy, typically they go sort of hand in hand. You're going to want a policy against unlawful harassment. You'll have a statement that the company does not tolerate unlawful harassment. You're going to want to cover all the protected categories again, even though California law specifically says that you need to have a policy, that employers need to have a policy that communicates that you do not tolerate and that you protect against sexual harassment. The policy really should be broader than that and include that the company does not tolerate unlawful harassment based on any protected status. And if an employee feels they've been the victim of some type of unlawful harassment, that they are told what to do about that and who to complain to and voice their concerns to. The government code, the Fair Employment and Housing Act in California, does have some specific requirements that must be included in your policy. I'm going to talk about those in just a second. You are also required to post the DFEH poster on discrimination in the workplace. So that's separate from your employee handbook. So that should be done as well. You want to provide each employee with a copy of your unlawful harassment and EEO policy and demonstrate that you've done that. California law requires you to do that. And so again, the most effective vehicle to communicate the policy to your employees is through an employee handbook. Could it be done by creating a separate standalone policy against unlawful harassment and hand that out to your employees or email that to your employees? Absolutely. There's more than one way to do it, but including it in the employee handbook is a pretty efficient way to do it. You want to make sure you're able to show that you communicated this policy to your employees. So the government code in California, the Fair Employment and Housing Act, does say that you have to have certain components of your policy. It includes the statement of the illegality of unlawful harassment, a definition of unlawful harassment under federal and state law, a description and example of harassment as well, how to complain, what their legal remedies are, how to contact the DFEH or the EOC. So your policy needs to specifically tell your employees how they can contact one of those agencies if they feel they've been the victim of unlawful harassment or discrimination, and that as a company, you prohibit retaliation. So there's different ways you can just communicate all this information to your employees, different words you can use to make sure it's clearly communicated, but the policy does need to include those components. In addition, the policy really should include a statement that there can be personal liability for supervisors if they engage in unlawful harassment, that your policy covers not only your employees, but also independent contractors and visitors and vendors, that there can be liability for acts of co-workers if they engage in unlawful harassment. Language to the effect that if you do get a complaint, you as a company are going to fully and fairly investigate. You're going to do a thorough and timely, prompt investigation if you get a complaint. And all of those words, all of that language should be incorporated in your unlawful harassment policy. As well, that once you do investigate, you get back to the employee about the results. And then you can include language about confidentiality, that when you do an investigation, that you will keep the results or the investigation itself as confidential as possible, but you're not fully guaranteeing that it will in all respects remain confidential, because just by virtue of doing the investigation, people are going to learn that something's going on, but you'll keep it kind of on a need to know basis. So those are all things that can be and should be included in your unlawful harassment policy. Another policy, let's see, do we have questions, Hillary?
No, not that I see, not right now.
Very good. Thought I'd pause for a second before I moved on. So another area of key policies to include in your employee handbook are policies regarding leaves of absence. Again, different employers have different philosophies about how much information they want to communicate to employees about leave of absences. I think we have done, for the chamber, and you've probably been to other seminars, that talk about leave of absences specifically, and that there's a long laundry list of ways that employees in California do not have to come to work, and there's a lot of leave of absences that are recognized under California law. An employer can choose, which of those leave of absences they want to reference in their employee handbook to communicate to their employees. The law in California does not require that an employer communicate all of those leave of absence rights to employees, but some of the leave of absence policies do require that an employer let their employees know about their rights for different types of leaves of absence. And one of those has to do with the FMLA and the California Family Rights Act. This is a type of leave that an employer is required to communicate to their employees. And there are aspects of this policy that are helpful to you as an employer if you do communicate the details to employees. And in the course of creating the policy itself, you have to make decisions about what your policy is going to look like and how it's going to function. And if you don't make those decisions on the front end, then if you end up in litigation, it could be that a plaintiff's lawyer or a former employee is making those decisions for you because you didn't take the opportunity at the front side of the employment relationship, or even now, if you are rolling out an employee handbook in the near future, you didn't take that opportunity now to establish a clear policy. So important then for companies to have an FMLA or California Family Rights Act lead policy. So who has to have a policy like this? Well, until the first of this year, everything I'm about to say about these policies only applied to companies with 50 or more employees, because both the FMLA and the California Family Rights Act only applied to companies with 50 or more employees. That changed on January 1 of this year, and now the California Family Rights Act applies to companies with 5 or more employees. So more and more companies are obligated then to have a policy, or at least highly recommended to have a policy, so that you do communicate to your employees what their rights and expectations are with respect to this type of leave of absence. And so the FMLA threshold is still 50, that's on the federal level. If you're a California employer with 50 or more employees, then you're going to be covered by both the FMLA and the CFRA. But if you're under 50, then but 5 or more, then you now have to comply with the CFRA. So the policy is required to be communicated to your employees. So you want to make sure you have a clear and effective leave of absence policy. The policy should state the policy typically is fairly long, and I'm not going to address here every element that needs to be in your FMLA policy. But one of the things you're going to communicate is that the employees are entitled to up to 12 weeks of unpaid leave under the FMLA or the CFRA. And you're going to communicate to the employees the reasons why they can take a leave of absence. So under the CFRA and the FMLA, there are kind of 3 basic categories. One is that if the employee has a family member who has a serious health condition, the laws define who qualifies as a quote unquote family member. The rules are slightly different under the CFRA and the FMLA, but your policy will explain that if you have a family member with a serious health condition, then you could be entitled to up to 12 weeks of unpaid leave. The policy will communicate that only certain employees are eligible for the FMLA leave or the CFRA leave. So an employee, for example, has to have worked for the employer for at least 1,250 hours in the last year and have worked for the company for at least 12 months as well. So a brand new employee, a relatively new employee who has a family member with a serious health condition may not be entitled to the up to 12 weeks of unpaid leave because they don't meet the eligibility requirements. The FMLA and the CFRA before January 1 also said that you had to have that certain number of employees. Prior to January 1, it was 50, within 75 miles of each other. So if you had multiple small locations that were spread out around the state, even though you may have had more than 50 employees collectively, each of those locations may have been less than 50 employees and more than 75 miles from each other, in which case those employees at those locations were not covered by the FMLA or the CFRA. But the amendments to the statute, the CFRA, that went into effect January 1, eliminated that 75-mile rule. And so we don't deal with that now so much here in California under the CFRA. So you're going to communicate to the employees the different reasons they can take the leave. As I mentioned, one of them is that they have a family member with a serious health condition. The other is that the employee themselves has a serious health condition. Another may be that the employee has what's called a qualifying exigency, which is for employees who are associated with the military, or for example, the employee or their spouse is getting called up for active duty and has to deal with some issues in connection with being called up for active duty. They may be entitled to some time off under the CFRA and the FMLA for those purposes. So all of these things, you need to explore and include in your policy to make sure that the employees know the reasons they can take the time off. One of the reasons that, and it's important that an employer do this in advance, that they take the time to create their own FMLA and CFRA leave of absence policy, is that there are some decisions that have to be made as to what your policy is going to look like. And so you see there where I indicate that the employer must select how it will measure the 12-month period over which the 12 weeks of leave may be taken. So the law says that they get 12 weeks of unpaid leave in a 12-month period, but there are obviously different ways to calculate a 12-month period. And the law says that you could, for example, use a calendar year or a fiscal year. That's typically not recommended, even though that's a simple way of doing it, because an employee could stack their leave by, for example, if you're using the calendar year, they could take 12 weeks at the end of one year and then turn around and take another 12 weeks at the beginning of the next year, and they would essentially get 24 weeks off. So for that reason, using the calendar or fiscal year is generally not recommended. But you can use a rolling forward method, a backward looking method. You need to analyze that and decide what's best for you and get some advice on that process. But keep in mind that if you don't clearly communicate how you're going to calculate that 12-month period, if you don't have a policy at all, or if the policy is silent on that point, then if an employee is suing, then that employee or their lawyer may say, well, we get to choose then which 12-month period we're going to use because you didn't take the time to do it as an employer. So it's very important to make sure you craft this policy carefully and you communicate these things and other important details to employees.
So Dan, I don't know, did you see Janice's question about the maternity leave in the chat?
No, let me look.
I don't know if you answered it or not.
I didn't, but that is perfect timing because I'm just about to move to pregnancy disability leaves.
Perfect.
So actually, let me read the question first, and I'll try and incorporate that as I address this. So everybody can see it, but let me go ahead and read it from Janice. It says, for maternity leaves postpartum, 12 weeks starts after the 6 to 8 weeks postpartum. Do small employers required to pay for healthcare insurance during time off? Example, employee took off 1 month before delivery, 6 to 8 weeks after labor and delivery, then 12 weeks for baby bonding, total of 5 months off. Okay, so let me explain a little bit about the policy first, and then this question will actually be a good opportunity to explain some of the details about leave of absences. And so a key policy, along with your FMLA CFRA policy, is to have a pregnancy disability leave policy. And really every employer should have one of these also, at least if you have 5 or more employees. The law does require you communicate to your employees your PDL policy. It should explain the difference between allowing an employee a leave of absence under the policy versus an accommodation, which is sometimes requested by a pregnant employee, that they don't necessarily need to be away from work, but they need some type of accommodation in order to do their job. And your policy should address both of those circumstances. California law provides that employees can take up to 4 months of unpaid leave during the PDL time period. Technically, I guess it's referred to as 17 1/3 weeks, but it is, a simpler way to think about it is 4 months of unpaid leave. Health insurance benefits must be continued while she is off on the disability leave, and your policy should also, reference that she has the right of reinstatement following the PDL leave. So first of all, it's important to recognize that this time off that she's entitled to related to her pregnancy is, as the law states, it's pregnancy disability leave. So in order to get the up to 4 months worth of unpaid leave, she needs to be disabled related to the leave. And so I don't necessarily want to launch into an entire seminar, I guess, on PDL leave, but just to hit some of these highlights, she does need to be disabled. So as we know, not every pregnancy results in the woman being disabled. Some women can work basically right up to the day the baby's born, never take any time off, not be disabled, typically would then have some period of disability after the baby's born, typically 6 to 8 weeks, depending on whether it's a C-section or the form of birth, but typically her doctor will take her off following the birth for at least that amount of time. And other women have more complications and have, need time off because she's put on bed rest or has other issues related to the pregnancy well before the baby is born. So, every woman is different, every pregnancy is different, and the employer just needs to be prepared to address those issues and deal with them, as the on an employee by employee basis. So they can get up to the 4 months worth of time off, and that time off can also be taken intermittently. So it doesn't have to be 4 consecutive months. It could be a week here or a day here or an afternoon off because of morning sickness, or could be a lot of ways that the employee could be entitled to protection and time off because she's disabled related to the pregnancy. So all of those things need to be incorporated in your policy, and it's a fairly simple process to do all of those things. Now, the pregnancy disability leave overlaps potentially with other forms of leave of absence, and that's the question essentially that Janice is asking, because in addition to an employee getting FMLA or CFRA leave for the reasons that I had already stated, the serious health condition of the employee, a family member, qualifying exigency. Another way that someone could get CFRA, FMLA leave is for baby bonding time. Once an employee has a baby or adopts a child or has foster care, something along those lines, a new child's entering the home, then they could potentially get the CFRA or FMLA leave for that purpose. In California, pregnancy disability is not considered a serious health condition under the California Family Rights Act, which means that even though she's disabled related to the pregnancy, the California Family Rights Act time period of up to 12 weeks of time off because someone has a serious health condition is not triggered. And that's because we have these two distinct laws. We have the CFRA and we have the pregnancy disability leave law. So when someone is disabled related to a pregnancy, then that is the leave of absence that basically takes priority over the CFRA leave. On the other hand, the CFRA does have the baby bonding component. So getting then to Janice's question, she says that for maternity leaves, postpartum, 12 weeks starts after the 6 to 8 weeks postpartum. So essentially what we're saying is that the pregnancy disability leave is taken first, and the baby bonding leave is not going to be taken until the pregnancy disability leave ends. So a woman could be disabled related to the pregnancy before the child's born, but also after the child's born. So postpartum, the doctor could be taking her off of work for a variety of reasons. It could be the recovery from the delivery itself. It could be recovery from surgery. It could be postpartum depression. It could be other things that are related to the pregnancy that she's still disabled. And so until she finishes using that pregnancy disability leave, the baby bonding time is not going to begin to run. Now, if someone has already used up all of their pregnancy disability leave, say before the baby is born, then it could be that the baby bonding time would begin immediately after the baby is born. In Janice's question, she's asked a couple of things. So she says postpartum 12 weeks starts after 6 to 8 weeks of postpartum. I think what you're saying and what I've already answered, that is we use the PDL first, and then we start the baby bonding time. Do small employers required to pay for healthcare insurance during time off? Yes, both the CFRA and the PDL leave, the pregnancy disability leave law, require employers to continue health insurance while they're off on those protected leaves. In the example, the employee took off 1 month before delivery, 6 to 8 weeks after labor delivery, and then 12 weeks of bonding, total of 5 months off. Yes, that is very possible for that to occur based on that sequence of events and the use of both the PDL and the baby bonding time. So hopefully that explains a little bit about the area of law and also answers Janice's question. But these are things that employer needs to watch carefully and recognize that, you know, when an employee does tell the employer that they are pregnant, that she is entitled to a lot of protections in terms of her job, both while she's still working and also from a matter of right of reinstatement following the PDL time. So those are a couple of key policies that I think need to be included from a leave of absence standpoint. Another leave of absence policy that employers are obligated to communicate to their employees relates to domestic violence, sexual assault, and stalking. If an employee is a victim of any of those things, then an employer is obligated to give them unpaid time off to address those issues. And you are required to have a policy that communicates to your employees that they have these rights. So that could be communicated to employees through the employee handbook. It could be communicated to them by use of one of the pamphlets that's created by the Department of Fair Employment and Housing. I think that's the agency. It could be the DLSE. So that could be communicated that way. But employers of every size have an obligation to accommodate an employee and give them unpaid time off to deal with getting relief from the court. And it also applies whether the employee is the victim, but also if a family member is a victim, then they need to be allowed time off to deal with those issues in court. And if you are an employer with 25 or more employees, then you also need to accommodate an employee and give them some time off potentially to seek medical attention or counseling. So those are all things that need to be included in your policy. Another key policy I believe is critical for employers in this day and age are meal and rest period policies, where you clearly communicate to your employees what your policy is regarding meal and rest periods. This may seem mundane, it may seem simple, it may seem that, well, everybody knows, what the meal and rest period expectations are, but it's critical to have these reduced to writing and have these communicated to your employees. And the reason is that having this communication about your policy to your employees can provide you with some defenses or give you things to argue if you're subjected to some type of wage and hour claim. As an example, with the labor commissioner, if an employee files a claim with the labor commissioner, and let's say one of their claims is that they didn't get their rest periods, okay? They didn't get the 10 minutes of rest for every 4 hours of work or major fraction thereof. It would be pretty common for the deputy at the labor commissioner to ask the employee making the claim, well, did you receive the employer's rest period policy? And typically the employee will say yes, or were you aware of it? Yes. And one of the next questions the deputy is going to ask is, well, if you were aware of the policy, why didn't you take your rest periods? And the employee may have an answer to that, may be able to explain that somehow the press of work or other requirements prevented them from taking their rest period. But the fact that the employer had a policy and had published it to their employees, could take the employer a long way toward defeating that rest period claim, because the labor commissioner, for the most part, is going to expect employees to follow that policy if communicated to them. In individual litigation or in class action, a potential similar result. The plaintiff's lawyers are immediately upon filing litigation requesting that the companies provide a copy of their meal and rest period policies. And they're scrutinizing those policies very carefully to make sure that the employer is accurately communicating to the employees the law related to meal and rest periods. So you want to make sure that you have good meal and rest period policies, that they're accurate, they're comprehensive, and that they're pushed out to your employees, presumably through your employee handbook. So when you're looking at those policies, some of the things you're going to want to look at is that you're communicating to your employees that they are eligible for the rest period for every 4 hours of work or major fraction thereof, to have language similar to or major fraction thereof. That quote is taken directly from the wage order. There might be other ways of phrasing it, but the same concept. So don't just, for example, say that they're eligible for a net 10 minutes worth of rest for every 4 hours, okay? That is true, but better to have the complete statement that it's 4 hours or major fraction thereof. And that they do get the 10 minutes, that it should be taken near the middle of the 4 hour period. Details like that should be included in the policy, that they're free to leave the premises during both their rest and meal periods. That's a change in the law. A few years ago, employers typically would restrict employees to stay at work for a rest period, but allow them to leave for meal periods. Now that policy should state that they're free to leave the premises for both rest and meal periods. Give examples of how an employee might be entitled to additional rest periods beyond an 8 hour day, because the law does allow them the net 10 minutes of rest for every 4 hours. So if they work more than 8 hours in a day, they're going to be entitled to more rest periods through the course of the workday. With respect to meal periods, describe how they're entitled to the first and the second meal periods, that the first meal period must be started by the 5th hour of work, and maybe even give an example of how that's going to be calculated. That if they start at 8 o'clock in the morning, then that meal period should begin no later than 1 o'clock p.m. If you're starting the meal period at 1:15, then, and you give them 45 minutes, well, you've met the requirement to give them a minimum of a 30-minute meal period, but you have not met the requirement to give it to them within by the 5th hour of work. So you want to make sure that it's clear how much time they get, the minimum of 30 minutes, net 30 minutes, and as well as when they get it. Describe the second meal period and how that can be waived. Describe that the meal period is unpaid, duty-free, and uninterrupted. Provide a complaint procedure for employees if they feel they were not giving their meal period or rest periods properly. And then just generally understand that although the Brinker restaurant decision from a few years ago was a good decision for employers, in that it said to employers that the obligation is simply to, quote unquote, provide the meal period, as opposed to ensure that the employees take it, that the way the law has evolved and the way the enforcement has evolved, really it comes down to that an employer does pretty much need to make sure that their non-exempt, their hourly employees are getting their meal periods. And again, it's got to be, for the meal periods, a minimum of 30 minutes, 28 minutes, 29 minutes doesn't cut it. And that you still have liability if you don't give a full 30 minutes of meal period. In addition, at least your practice should be that employees must record their meal period, okay? That capturing in some way, either on a piece of paper or with a time clock or a phone they're using, some electronic methodology, that you're capturing when the workday begins, when the meal period begins, when the meal period ends, and when the workday ends. So you want to make sure that all of that is part of your practice and policies with respect to your meal and rest periods. Similar to the meal and rest periods, I think it's important to have, as part of your key policies, something describing your payroll practices, that employees are expected to record all their hours worked, that you don't tolerate any off-the-clock work. It's not permitted. Explain overtime compensation, what the rules are in California for the daily and weekly overtime. You can state that overtime must be authorized before it can be worked, but it's also important to make sure employees understand that if they work it, whether authorized or not, they're still going to get paid for it. So I think that's important to incorporate in your overtime policy. Describe your pay periods that employees are subject to, and give the employees a reporting method for wage and hour discrepancies or missed compensation, that they're expected to let you know if they didn't get paid correctly, if something's missing from their time card or missing from their pay stub, that you want to know immediately if there's a problem and give them a methodology to do that. And I think that's important to include in your policies. Addition to those, I think it's good to have policies that talk about employees' time away from work. So it could be an attendance and punctuality policy. I think that's important to have, just so that if employees are not following that expectation that's set forth in your employee handbook, that you have something to point to when you discipline that employee or potentially terminate them down the road, that they're not adhering to your attendance and punctuality policy. A vacation policy, you're not required by law to offer employees vacation, but if you do offer vacation, then California has rules that you have to follow to do it correctly. And your policy should describe how that vacation time is going to be accrued. How much is being accrued on a daily or a weekly or a monthly basis based on the number of years of service. So you want to spell that out in your policy. Understanding that in California, vacation is considered to be accrued basically on an hour by hour, day by day basis. So, it is something that's accruing on an ongoing basis, and that should be included in your policy, that it is accruing on a regular basis. So clearly communicate how that is going to be happening for your employees. Also include in your vacation policy language that shows how you're going to manage your accrued vacation liability. And what I mean by that is that, if employees accrue vacation but don't use it, California law says that companies in California cannot have what's called a use it or lose it vacation policy. Once it's accrued, when the vacation that is accrued, then it's considered essentially vested, and the employee is entitled to that time off. But sometimes employees will not use their accrued vacation. And so then the employer has to decide, how am I going to manage that accrued vacation liability? If I just let this employee continue to not take their vacation, then they could end up with 6 months worth of accrued and unused vacation on the books, which I may eventually have to pay when that employee no longer works for me, or pay out because the employee now says, I want to take 2 months off. So better for the company to have a way of managing that accrued vacation by either establishing a policy that you will pay out the unused vacation each year that the employee does not use, or establish a cap on the accrual that says that once an employee accrues up to, say, 1.5 times or 2 times their annual rate of accrual, that they will no longer accrue vacation until they use up some of their vacation. And the labor commissioner has said that that is not the same as use it or lose it. And the rationale being that if you put a cap on it and they hit that cap, then they're no longer accruing it. You're not taking away something they've earned. You're just telling them that they're not going to accrue anymore. So it's important, I think, to include that in your policy. Was there a question, Hillary?
Tanya had asked, do you recommend adding the verbiage regarding the new requirements on how to calculate premium pay?
Good question. So Tanya's question has to do with the calculating premium pay. And so this, I think the question probably had to do more with overtime, as I was back on that point, and also for meal and rest periods. So I think that's the basis for Tanya's question. So let me explain that a little bit first, and then talk about whether that's a good thing to include in the policy itself. So there was a court decision that came out a few months ago, that said that with respect to, well, actually, let me back up. So what I didn't say earlier with respect to meal and rest periods is that if an employer does not give their employees their meal and rest periods in accordance with the law, then the employer can be obligated to pay a penalty, so to speak, a premium to the employee for not complying with their meal and rest period obligations. And the premium is 1 hour of additional pay for a meal period violation and 1 hour of additional pay for a rest period violation. So if on a particular day, an employee wasn't given a meal period, for example, when they should have been, then the employer would owe that worker 1 hour of pay at their regular rate of pay for missing the meal period, or for not giving it to them on time, or because they got interrupted, or because it was only 28 minutes, a whole host of reasons the employee may not have been given their meal period or a rest period in accordance with the law. Then every day, any day that happens, the employee could be entitled to 1 hour of additional premium pay. And so if on a particular day, an employee missed both a rest period and a meal period, it could be 2 hours of pay, one for the rest and one for the meal. And so that isn't a 1 hour of pay at their regular rate of pay. So recently, a court said that if an employer is paying an employee some type of bonus, then, or incentive pay, then that bonus or incentive pay has to be included in the calculation of that 1 hour of pay at the regular rate of pay. So if for the time period the employee got that hour premium, then they also got a bonus, then the employer would need to factor that bonus back across the time period over which the employee didn't get the meal and rest period. And the effect would be that that 1 hour premium pay may be higher than their standard hourly rate of pay. So if they normally made $15 an hour, it could be that that premium pay is not just 15, but it's more than that, because we have to factor in the bonus across the time period over which they earn the bonus. And similarly, employers are obligated to factor that bonus or that incentive into an employee's overtime compensation rate of pay. So if an employee is earning, of course, time and a half for overtime compensation and double time if they work over 12, then when we factor that overtime rate, if they received a bonus, then you have to factor that bonus back across the time period over which the bonus is earned, and that raises the effective hourly rate of pay and then raises the overtime rate as well as this meal period and rest period premium. So that's a lot of explanation, I know, a lot of history, but I believe that Tanya's question is, should you incorporate that issue in the policy itself and explain that the overtime rate could be included, the bonus could be included in the overtime or rest period and meal period premium calculation. So this is all very new in terms of at least in terms of the effect on the meal and rest periods. I think that I think it would be a good idea to include that, both because it demonstrates that the employer is aware of the issue, and also if you do end up in litigation and plaintiffs' lawyers are scrutinizing your policy, it makes clear that you're aware of it and you're addressing it. But I would only include it if you are actually on top of the issue and are making sure that that calculation does get made on a regular basis. So it's not required as a matter of law that you include that new concept in either your overtime or your meal and rest period policies. But I think it could be a good idea to at least make some passing reference to it. I would probably do it in a rather vague way, just to identify that you recognize the issue. I wouldn't get into a lot of detail about how it's going to be done, but I think it could be good to include in there. I don't think it's the end of the world if you don't include it. It's more important to know the issue and be addressing it, I think, on that point than to include it in the policy. But I don't think it's a bad idea to include it in the policy. So Tanya, let me know if I didn't answer your question, otherwise I'll move on. So any other questions, Hillary? No, okay. All right. So other issues with respect to time away from work, personal days, to describe to employees if they're entitled to some type of personal days off that you define and describe your holidays and how they're, which are the recognized holidays that you're going to use from year to year, how they will be paid for those holidays, in particular for your non-exempt or hourly employees, that they're going to be, whether they're going to just, if they work a holiday, for example, do they just get holiday pay? Do they get some type of premium for working on a holiday? So good to include that in your policy. Also, I think important to have a mandatory paid sick leave policy. That's the law that went into effect back in 2015 that we've been dealing with for several years now, that allows employees up to 24 hours or 3 days of paid sick leave for every 12 months worth of time, for every 12 months. So you need to decide if you're going to use the front load method of providing the sick leave, or you're going to use the accrual method. The statute allows you to choose between those systems. Address in your policy whether any time unused sick leave will be carried over and how much will be carried over. So those are important aspects of your mandatory paid sick leave policy. Just as a side, not really a handbook issue, but just in case you haven't heard, a lot of employers are getting sued for pay stub violations on the grounds that they are not including the amount of mandatory paid sick leave to which their employees are eligible on their pay stub. And that is a requirement under California law. The pay stubs show how much mandatory paid sick leave law the employee has available. So that's something that you need to pay attention to as well. If you have additional sick leave beyond the mandatory paid sick leave, then describe that in your handbook as well. If they're taking time off beyond the mandatory paid sick leave time, then an employer can ask for a doctor's note to support the time off if they choose to do that, and you can incorporate that in your handbook. If you have a paid time off, a PTO policy, where you combine the vacation and sick leave together, then you'll want to make sure you explain how all of that works for your employees as well. And then lastly, makeup time. If you are using the vehicle of what's called makeup time, where employees can work more than 8 hours in a day to make up time that they took off in that same work week, and not be paid overtime for that time of more than 8 hours, then all the details regarding your makeup time policy need to be incorporated in your policy also. Other key policies, I think, should address conduct in the workplace. So I think it's good to have a standards of conduct policy that set forth the various reasons that an employee could be disciplined. It's not going to be an exhaustive list, and the policy will say that it's not exhaustive, but I think it's good to lay out the reasons why an employee could be subjected to discipline, just really establishing the expectations of the employer for the employees in the workplace. It may also be useful to have a dress code policy depending on your employment and whether you have issues with respect to how employees are reporting to work. Important, I think, to have a workplace violence policy as well, to establish that you don't tolerate workplace violence, and that if employees engage in violence, that they may be terminated. Good also, I think, to have a reference to your drug and alcohol policy. Really, if you have a true full-blown drug and alcohol testing policy, that should be a separate document, separate and apart from your employee handbook, but the handbook can still sort of summarize what the employer will be doing with respect to drug and alcohol testing in the workplace. Also, good to have confidentiality language that the employer expects employees to maintain confidential trade secret and other confidential business information, and cannot share that outside of the workplace. Good to establish your employee classifications, define what a regular employee is versus someone who's there perhaps on an interim or temporary basis. Define who a full-time and a part-time employee are. Perhaps define the introductory period. Again, not using probationary, as I said earlier. Make a general reference to who's considered exempt from overtime versus non-exempt and hourly. Again, these things can be done in a fairly brief way, but I think good to establish those in your employee handbook. As well, I think to have a section on privacy and technology to communicate to your employees that they do not have any expectation of privacy as to their workspace, their desk, their computer usage, company email, company voicemail. Those things are all subject to search by the employer, and that anything that's contained in those workspaces or within that technology is fair game for the employer. If you have a GPS on your vehicles or use other type of surveillance in the workplace, cameras, for example, then I think it's good to publish that to your employees to let them know that you are utilizing those services to obtain information and to track their whereabouts in the workplace. I think it's also good to have an email policy that explains that employees are expected to follow protocols, especially policies against unlawful harassment, et cetera, in the workplace through their email, that they need to be careful about what they write, et cetera. They should be professional. Similarly with the internet and social media, as well as blogging, those things can all be incorporated in your policies to explain what your expectation is as an employer. Similarly with electronic devices, that those belong to the company, whether it's a laptop or the company cell phone, that those are things that they do not have an expectation of privacy about, and that those are owned by the company and should be used for business purposes and professional purposes only. As a side note, not really an employee handbook issue necessarily, although it could be included in the handbook. Just wanted to note that one of the claims that we see being brought more and more is for reimbursement for cell phone usage, that if a company is requiring an employee to use their personal cell phone for work-related reasons, or even if it's not an official requirement, but the basic expectation on a day-to-day basis is that they be available by cell phone for work-related reasons, then the employer should be reimbursing the employee for some pro rata cost of that cell phone. So most employers are establishing just a flat amount. They pay the employee every month, for that portion, so to speak, of their personal cell phone that is being used for business purposes. So another policy here is an arbitration or dispute resolution policy. So just my first bullet point there is that even though I'm addressing this here as a key policy, it technically wouldn't be in your employee handbook. So I just want to make that clear. If you're going to use an arbitration provision, an arbitration agreement, it should really be a separate document. It can be rolled out with the employee handbook. It can be behind the employee handbook as part of that documentation, but it should be a separate document. And it is something that employers should consider as they're evaluating their employee handbook, whether you're starting one from scratch, you're having one reviewed, whatever stage you're at with respect to your employee handbook, it's a good idea to consider whether you want an arbitration agreement as well. The arbitration agreement essentially would have the employees waive the right to a class action claim. It would include a waiver of a right to a jury trial, would require employees to arbitrate their claims, take their claims to an arbitrator through an arbitration process as opposed to litigation. But as you're evaluating that you also need to educate yourself about the pros and cons of an arbitration agreement. And I'm not going to go into all the detail on that right now. That would be, we'd spend another 20 minutes just talking about arbitration agreements, but just to point the issue out to you that it's something to consider, as you're evaluating your employee handbook. Well, a policy that we need to have is part of your policies, typically at the end of the policies, is that you want to have acknowledgements and sign-offs, of the employee handbook. So behind the handbook, as you're distributing it to your employees, you want to have them sign a receipt of the employee handbook, an acknowledgement of the relationship and a separate policy, an acknowledgement of the meal and rest period policy, an acknowledgement of your EEO and unlawful harassment policy. Okay, so all of those things would be separate sign-offs behind your handbook to give yourself the added protection of being able to establish that you published all of those things to your employees. All right, so beyond that then, beyond the key policies that I've addressed that I think are the most important, there's a lot of other policies that employers commonly include in their employee handbook. As I said at the beginning, virtually none of the things that I've talked about are absolutely required, other than the ones that I said at the top of the presentation. But other things that employers commonly include in their employee handbook is a section, for example, on requirements for employment. So you're telling the individual as they're coming on board that they need to complete certain appropriate forms as part of their personnel file. It might be an application, it might be the right to work in the US, that they have to be in the physical condition to perform the job, that maybe you're going to have medical exams or pre-employment drug and alcohol examinations, that the employee needs to remain insurable under the company's insurance policies in order to stay employed. So those kinds of things can be incorporated in the handbook. You could include a reference to terminations, layoffs, and recalls. You could address how final paychecks are going to be handled. In California, if an employee is involuntarily terminated, you have to give them their final paycheck on their last day of work. If they quit, then without notice, then you have 72 hours to give them their final paycheck. But if they've given you 72 hours or more notice that they're going to be leaving, then you have to have their final paycheck ready for them again on their last day of work. So that can all be included in your policy if you choose to do so. If you use exit interviews for employees who are on their way out the door, then you can incorporate that in your policy. You can make a reference to COBRA benefits, and as well as how you as a company will handle employee references if they're seeking a reference from their next employer. So those things can all be covered in your policy. It's good to have a policy that addresses safety. Most companies will, separate from their employee handbook, can and should have an injury and illness prevention program, an IPP. And so that will more comprehensively cover safety issues. But, having a policy statement in your employee handbook that also expresses the company's interest in having a safe workplace, that you want to make sure employees tell you if they have had an accident or an injury or observe some type of unsafe condition. So incorporating that in the employee handbook as well as the IPP, I think is a useful thing for employers as well. Presently, based on the publication of the Cal OSHA last year, I think it was effective in November last year, employers are supposed to also have a COVID prevention program in place. That should be separate from your employee handbook, but that's something that's been required here for a few months. If you don't have one of those, then that is something you should be trying to establish as well for your workplace. Some clients have asked whether they need to include anything specifically in their employee handbook with respect to COVID or how they're dealing with COVID. I think that's an employer's choice. You could add language, for example, in the safety section about that issue and that you're taking it seriously. You could have an addendum to your employee handbook that addresses COVID and issues related to COVID. But I don't think you're required to have it. I don't think you need to include COVID information in your employee handbook right now, especially if you establish that COVID prevention program that the Cal OSHA had mandated last year. So that's kind of the employer's choice whether they want to go above and beyond that. Also a good idea to include in your employee handbook, or at least commonly included, is benefit eligibility, that if employees are entitled to, for example, health and welfare coverage or life insurance or other benefits like that, then you can list those in your employee handbook. I typically prefer that you don't get into a lot of detail about those benefits. Instead, I think better to refer the employees to the plan documents or to HR for all the details, but you can at least let them know that they're available to employees. You can include language that you have the right to change or cancel or modify those things as well. But I would keep this description typically rather brief because those things can change from time to time. When you go through open enrollment the next year, maybe some of the details that you include would be modified, and you don't want to have to keep changing your employee handbook just because the benefits that you offer have changed. So I think better to be more general in your description about the benefits available to employees. Some handbooks will also address personnel files. That is, that employees have the right to review their personnel file in the presence of a management representative, and that is something that they're entitled to by law. They have the right to add information if they want to their employee handbook. They don't get to change what's in there, but they can add their version of events. The employees can request a copy of their personnel file and payroll records. That right also extends to former employees. The employers have up to 30 days to respond to a request for a copy of a personnel file and up to 21 days to respond to a request for a copy of payroll records. And again, that's true for both current and former employees. So that language can also be included in your employee handbook. Some employers, as I said earlier, will also include references to additional leave of absences. And so the list is long. These are just some of them, but some handbooks will reference that employees can be entitled to time off, unpaid time off, if they're a donor of bone marrow or an organ, for jury duty or witness leave, bereavement leave, time off to attend a literacy program to learn to read, if they're a victim of a violent crime, if they need time off for their children and dealing with issues at the school. Volunteer firefighters can have unpaid time off as well. Individuals dealing with the Civil Air Patrol can also get time off unpaid, and military leave as well. So again, none of these things are required by law to include in your employee handbook, but if you would like to explain those options to your employees, both so that you have it as a resource from a management perspective, as well as them understanding that there are opportunities for them to take time off for those reasons, then that's your prerogative to include those in your employee handbook. All right, so those are, again, kind of some of the common policies that are included in employee handbooks. Let's change gears here to talk about just implementation and distribution as we get toward wrapping up. First of all, in terms of sort of the creation of your employee handbook, you have a lot of latitude to make the handbook have a look and feel that you like. So it's yours. There's no, legal requirements as to, what the handbook is supposed to look like. It could be stapled, it could be bound, it could be in a binder, it could, be very fancy or very simple. It's up to you. I think it's good to maybe keep it simple from the standpoint that if you have to make multiple copies of it and distribute it on a regular basis, being able to do that in an efficient way is useful. As you're creating it, you're going to want to avoid ambiguities and lack of clarity. General rule is it's better to have no handbook than a poorly drafted handbook. And so and still keep that in mind, even though, as I said at the very beginning, I do think that handbooks are important as part of an employer's general practices. And avoid adding the kitchen sink, though. To get into way too much detail can create problems for employers, both because it takes forever to draft it, and it takes a lot of time then to continue to update it on a regular basis. So as you're thinking about creating an employee handbook, and it's a good idea to gather your existing policies and procedures that you have already, evaluate those, evaluate your current handbook, talk about maybe among the management staff, what things you'd like to see change, and where you think your handbook might be outdated or maybe either has too little or too much information. If you have some employees who have specific employment agreements or specific employee contracts, then you want to gather those as well to make sure that the employee handbook is relatively consistent with those. If an employee has a specific employment agreement, then though the terms of that language may trump the employee handbook. And so you want to make sure that the contract talks about that issue as to whether or not the employee handbook is something that is applicable to the employee along with the contract, or if the contract overrides the employee handbook. Review your applications for employment to make sure there's nothing in those that are inconsistent with your employee handbook or what you'd like to have in your employee handbook. If you have, for example, personnel action forms, where, the disciplinary forms, for example, make sure those aren't inconsistent with your employee handbook. An example might be if your personnel action form, creates the impression that you're going to follow certain progressive discipline before you terminate an employee, you want to make sure that personnel action form is modified so that it's clear that those different options, for example, a verbal warning or a written warning, are not things that the employer is required to follow, but the employer has discretion as to if or when they're going to engage in those particular progressive discipline steps. As I mentioned, gather your management team and evaluate the changes. Ultimately, good idea to have your handbook reviewed to make sure that it's compliant with California and federal law. Sometimes you need to customize your handbook. If you're doing business in multiple states, then one size fits all may not work for you. Different states have different obligations, and obviously California has some very unique requirements that other states don't have. If you are a unionized employer and covered by a collective bargaining agreement, then you may have some special terms you need to include in that, and you may have an obligation to negotiate with the union about the about the employee handbook. Another example might be, I've had companies want a different version of their handbook for their office staff, perhaps, versus their field employees, and that's okay for you to consider as well. When you distribute the employee handbook, you'll want to meet with the employees typically to explain what you're doing, give them an opportunity to review it, answer questions. If some employees refuse to sign for it or refuse to sign the forms, then you may end up scheduling individual meetings with them to talk about that and why they won't do it. We can talk through some types of subtle pressure you might be able to put on them to get them to sign it. But ultimately, if they don't sign it, it doesn't mean it's not applicable to them. It's just that they haven't signed it. Want to get your appropriate documentation. Those are all the sign-offs and acknowledgement forms that I mentioned earlier. And make sure you have a process of giving the employee handbook to your new employees as they're coming on board and through the onboarding process. Okay. So a lot of information about employee handbooks. I'm happy to answer any other questions. Are there any pending yet, Hillary?
Yeah, we have a few that came in. One of them, so John Pandel asked for employees who have had COVID, any documentation to be used in lieu of vaccination certificates and negative PCR tests. And then he also followed up and said, are you aware of any document that can be used in this case? And those are in the Q&A. I think you can see the questions.
Okay, great, thank you.
Uh-huh.
So one of the options an employer has with respect to documenting or finding out where employees stand with respect to vaccinations is that you can do use a self-attestation type form. And I don't know if that's incorporated in John's question or not, but where you give to your employees a form and they check, where they are with respect to the vaccination process. They can indicate that they've been vaccinated. Maybe an option is that they've gotten one shot, but not the second, or that they don't intend to get vaccinated. So that is one way of documenting where people are. So to the extent that the question is asking, could be something you use in lieu of a vaccination certificate where they just self-attest to their status. Otherwise, I'm trying to make sure I kind of understand the question or kind of what was intended by it. If the employer, if part of your question is that you're intending to mandate vaccines, or as we are anticipating, OSHA is supposed to be issuing new regulations, emergency temporary standards on a federal level applicable to companies with 100 or more employees to mandate vaccines, then in addition to the vaccination certificates, that self-attestation could work. But also, if the employees would be, what we understand the new regulations will probably say is that they either need to be vaccinated or provide weekly tests, and so employers will be struggling with how to make that happen. As I'm understanding from talking to different clients, I haven't actually researched this thoroughly myself, but apparently some of the home tests that you can purchase can meet the PCR requirement. So you may be able to get those tests obtained basically in the work site without spending a lot of time having the employee run to an urgent care or expend more money than you need to on the test themselves. So that might make the testing process a little bit simpler going forward.
And Dan, I unmuted John if he added to his question. If it's easier, John, to ask it.
Yeah. We'll have employees that will be, traveling, and as they go to different locations in the country, I have an event in New York City which will be requiring vax passports. What I'm thinking of those who have had COVID and think that they don't need the vaccine, and retesting seems to be silly. Are you aware of any or hearing of anything that's out on the horizon that may be used in lieu of that?
I see. Okay, good. I'm glad you clarified. No, I haven't heard of anything specific that could be used in lieu, because there are, kind of incorporated in your question, there are a lot of individuals who believe that if they've had COVID, that the vaccination is unnecessary. And there's probably some scientific support for that you do have a lot of protection from antibodies and such, by virtue of having had COVID. But I'm not aware of any methodology that people are considering that somehow you, I guess, would be demonstrate that you've had COVID, but somehow, not have to then comply with the requirement that you show proof of vaccination. So yeah, sorry, I haven't heard of anything new coming up.
Thanks, John. And then along those lines, Gordon had a question he typed in the chat. When dealing with contractors with your company, should you have a similar document? I'm guessing that was COVID related. I'm not sure. Gordon, you're welcome to unmute.
Can you hear me?
Yes.
Okay. No, I was more referring to the entire document as a whole.
Okay.
The employee handbook.
Yes.
So,
And it's understood that there's some parts of that document you're not going to want to give, to, have contractors, relate to, like time off and stuff like that, but for the most part.
now, I would say as a general rule, I would say I probably would not give it to your contractors that are coming on board. If for no other reason, you don't want to create, to blur that line any more than it needs to be blurred as to who's a contractor and who's an employee. And an employee handbook is typically something that's directed toward employees, not contractors. Now, there may be rules that you want your contractors to follow when they're doing work with your employees or when they're on your premises. And you could create a separate sort of document that relates to expectations of contractors. But again, those would probably be focused more on safety issues and things like that than the typical things we see in employee handbook.
Okay, so what about like what was I going to say? Sexual harassment, stuff like that. Do you need that when dealing with them?
I think that your sexual harassment policy should make clear that it applies to independent contractors and vendors and anybody who your employees are having contact with, so that they understand that we don't tolerate harassment from any source in terms of how our employees do their job from day to day. I think that's a different, the question you're asking more though, should you communicate your policy against unlawful harassment to contractors who are coming onto your property or doing work with your employees? I think that's a good idea to do. I would probably make it a lot simpler. I wouldn't probably give them the whole unlawful harassment policy, although that wouldn't be wrong to do, but there's a lot of stuff in it that wouldn't necessarily apply to them. But I think communicating to your contractors that you don't tolerate them engaged in that type of behavior as to your employees wouldn't be a bad idea.
Okay.
Thanks, Gordon. And then Megan asked a question. Do you recommend the Cal Chamber California Employee Handbook Creator online tool for creating your handbook?
I think that's a very good tool. I think the Cal Chamber's handbook is good. It's been well vetted for over many years. So yes, I think that it's a good tool to use. I haven't checked the pricing on it in many years, but last time I did many years ago, it was priced, I think, very fairly. So I think it was a affordable tool as well. What I have found over time in talking to clients is that even though it is something you work through individually and select the policy that you want and to some extent tailor it to your own organization, it is still very time consuming and tedious. And I've had many instances where the job just never got done because it sat. That's different than your question, I know, but I think it's more important to get it done in some fashion, maybe more so than which tool you use. But I think the content of the Cal Chamber's handbook is good.
Thanks, Dan. Are there any other questions? Again, you can use the hand emoji or type it in. All right. If not, then you can reach out to Dan. His information's on this slide. It's in the presentation that I sent all of you. So thank you again, Dan, and thank you to LeBeau-Thelen for sponsoring today's labor law webinar. So I will, once this uploads the recording, I will send it out. Again, if you want to go back and review, if you have a question that you come up with, send it over to Dan. We will be planning another labor law forum in early December. So stay tuned for that announcement. Thank you all again for attending today. Hope you have a great rest of your day.